assumed to UPS was, I'm done working, it's not a problem. But they said, look, this is causing a problem with our customer, and so we don't want you to do that. So, but that would be another way around it. And what we did, we advised the customer, or advised UPS in our case. I shouldn't use UPS's name. They're a great company. Just happened to be their driver wasn't good.
Creepy.
Now I'm going to switch gears a little bit, and the same principles that we've been talking about with sexual harassment and sex discrimination apply in other forms of harassment. So it's any legally protected status. And this is what is very, very, very important. For Saul important, but this gets two varies in front of it. If an employee claims that his or her supervisor is creating a hostile environment, the first question you want to ask as the HR person or as a supervisor is, on what ground? Why is that person doing that to you? Because it's the why that is so important. Because if he says, because I'm not working fast enough, that has nothing to do with a protected category. So what are those protected categories? Race. This was the basis of the Civil Rights Act to begin with. That is unlawful to discriminate someone against someone because of their race. So you can have harassment, you can now have racial harassment, and this came out of the sexual harassment, because initially it was pretty easy to have a case of race discrimination by being terminated from your job. But what about while you're working and the environment's hostile or whatever? Was that a cause of action? And this then race harassment came out of the doctrine of cases with regard to sexual harassment. One that we don't see very often. In fact, I see it checked, and when you file a charge with the Indiana Civil Rights Commission or the Equal Employment Opportunity Commission, they have all the boxes, and you check the boxes. And usually if someone alleges race discrimination, they also allege color discrimination. But quite frankly, I've never handled a case of just true color discrimination. Most times that we put them in the category of race discrimination, but color is within the statute. Religion. This one is getting more and more attention, especially as we have people who claim that their religion requires certain things to wear, for example. A Muslim woman has to cover her head. Now we're seeing more and more people in the workplace, and how does that fit in with our corporate image? Well, if your image is that you want everyone to not wear something over their head, that may be religious discrimination, unless you can show that there is some safety reason or whatever behind that. But for the most part, that would be religious discrimination. You'd have to accommodate someone, and that accommodation would be, okay, we'll make an exception to our rules so you can wear your headdress or whatever. But it's also unlawful to harass someone because of their religion. And that could be something as simple, let's say someone is a real devout Christian, and they are constantly talking to their employees, to the coworkers about that. And you got a Muslim coworker, and if that Christian makes the Muslim uncomfortable at work because he's always trying to convert that person, that could be a problem, and that could be some sort of harassment. Again, if it's coworkers, it's not as crucial, in my opinion. It still could be actionable, but it's when you have a supervisor and a subordinate, that's really tougher for the employer to win, because it's automatically assumed that if the supervisor's doing it, it's the company doing it. So religion is another example of the type of discrimination that can occur. National origin. Someone has an accent. They may be from Mexico, for example. Well, is that race discrimination? Probably not. That would be an example of national origin. Can't make fun of someone because of where their ancestors are from. And of course, sex we already talked about. I'm very sensitive to this one. Anybody over the age of 40 is protected by the Age Discrimination and Employment Act.
Almost there.
And it used to, when the law was originally created, it was 40 to 70. And so if you're over 70, you could discriminate against someone because of their age. That got lifted. So anybody who's over the age of 40, welcome to the club. You are now protected. And one of the things that I think is unique about age discrimination claims is that for a jury, they're much more able to associate with an age discrimination claim because if all goes well, everyone will eventually be in that category. Not everybody's going to be in a religious category. Not everybody's going to be in a race category. But eventually everybody get there. And so those cases are always, and that's probably where we see, I would say at least 60% of the cases I would say that I see have an age component to them. Race is probably the other, and race and sex are pretty much equal, I'd say.
What if you have an employee that has got to, maybe a lot of times it is because of age, but they've got to the physical point of not being able to perform their job because of their age.
Right.
More because of their ability to do it, maybe age related, but
That's the difference.
you have
The
to document
difference is, yeah,
performance.
exactly. You still have to do the job. And so if someone is not able to do the job from a physical standpoint, then you've got to address that with the person and talk about in a review or an evaluation that you're not able to do the job. Where you run into trouble is if they are doing the job and you're saying, I think you're getting too old for this. Or you associate their inability, their physical inabilities with their age. Now, we all know that's a fact of life.
Just don't bring it up.
I mean, I'm not able to do, at my age of 63, bending down and doing all the things that maybe in the yard that I was doing when I was 30. I mean, that's a fact of life. But you can't say to me, you can't do that because you're too old. Now, you can have measurable tests to determine whether I'm able to do the job. That's objective. That's not age-related. So you draw a distinction between age and their actual abilities to do the job.
Like the NFL, I've never heard of cutting someone because they're 40.
Right.
It's cutting because they can't block.
Exactly. Adam Vinatieri, great example of that. He's 43 years old or whatever. If he wasn't producing, he wouldn't be on any team. But you keep producing, and so it's not age-related.
Right.
Disability, that can be physical, it can be mental, it can actually be emotional. Disability claims are, in my opinion, very easy to defend if you go about them right. In most cases are. But in disability, I think the key to this disability claim is you have to be able to do the job. And so if someone comes to you, and a case I just won in federal court, was an employee at a large hospital, and he was hired to be an IT person. Part of his job was to set up phone systems on someone's desk and their computer system and all that. But he claimed he had a bad back and couldn't get under the desks to crawl under there and do the things he had to do to set up someone's phone system and computer system. So what the company did was they said, okay, we're going to accommodate that. We're not going to make you do that part of your job. We'll bring someone else in to do that part, but we need you to do all the programming and stuff. Well, the guy couldn't do the programming. So they put him through some tests of programming tests, and he failed every single one of them. And he was terminated because he couldn't do the job. Well, he then filed a charge of discrimination, disability discrimination, and we were able to convince the court that that wasn't the reason the guy was terminated. He was terminated because he couldn't do the job, and this test that we gave him was related to the work that he had to do. So I think those cases are sometimes easier to win because you have to be, it's called otherwise qualified. You still have to be able to do the job. Now, in Marion County, is the only county around here that I'm aware of that has this law, that gender identity is now protected. So for anybody who works in Marion County, you could file a claim with the Marion County or the Indianapolis Civil Rights Commission of gender identity. Now, I associate myself, I think that I associate myself as female, but you discriminate against me, employer, because you think I really look male, but I'm identifying myself as female. That can be now actionable, but it's only Marion County because they created an ordinance to that. Kind of an interesting side note. I have we had a conversation with my oldest son, who's an orthopedic surgeon, and he was telling me that in the hospital, he works at Ohio State right now, and they are not able to ask someone on the form whether they're male or female. It's male, female, or what you identify with. So hospitals now are creating, what do you identify as? And they've actually had some battles with some patients who did not want to say they were male or female. And from a medical perspective, the doctors argue, well, yes, you are. I don't care what you identify as, but the doctors got in trouble because the hospital's trying to please the public and please the law. And so if someone comes in and asks, at least in the hospital setting, you're male, female, or who you identify, what do you identify as, don't be upset if the hospital asks you what you identify as.
I just read last night, just literally last night, there was a proposal for a law that they can claim non-binary, which, in other words, there's other box on there now, that they don't have to say they're male or female, but they're neither.
Yeah.
I don't understand, but that's the way it is.
But that's the way life is. Yes.
And then they choose what they.
All right, why are these cases important? Because if someone wins, they can get back pay. Because these cases take a couple of years to go through the court system. And so if they've been terminated from their job, they can be entitled to pay for the whole time that they were off work. So you're not getting any work out of them, but you're paying them for all that. Their benefits, and they can actually be reinstated to their job. Fortunately, I've not had a case where someone has ever been reinstated to their job because usually by that time they've found something else to do, but that's in the statute, they can get reinstated. And you don't want a person to be terminated and be forced to come back 4 years later and now you employ them again. They can get compensatory and punitive damages against the employer. Again, we're talking a lot of money. They can get their attorney's fees paid by the prevailing party, which would be if the employee wins, they get their attorney's fees paid, which is plaintiff's attorneys like that. Common law remedies, they can claim in addition to sexual harassment, for example, or racial harassment or race discrimination. They can claim invasion of privacy, interference with a contractual relationship, intentional infliction of emotional distress, and it also can be an assault and battery, which can be both civil and criminal. So you could actually get a criminal charge out of an assault and battery. I've actually had a couple of cases where an individual was touched at work in an inappropriate way, and they not only went the civil route, but they actually filed a claim with the prosecutor's office as well. So how do you avoid all this? Very important to have a written policy that encourages employees to report things. You want to ensure privacy safeguards. We talked about keeping these things confidential. That when you have a claim, we're going to investigate it. We're going to follow through with it. And this last one is important. Have other people that you're reported to. The reason for this is there was a case where the president of the company said, I'm the one that wants to know. So if you have a problem, I want you to tell me. Well, then he harassed someone. And the person then went to the EEOC instead of going to the company. And the company tried to argue, we have a policy that says you have to report these things. And she won her case because there was no other person to report it to. So what we like to see in a policy is, report to HR or a member of management, for example, to give that someone an alternative person to report it to. Be aware of situations. Keep your eyes and ears open. If you see or you sense someone is being harassed at work for any of these reasons that we've talked about, investigate it, talk about it, document it. Investigate complaints. Don't just push them under the rug. If someone is serious enough about something to bring it to your attention, or you observe it, investigate it. And in your company, that should all be reported to